So this section 248 talks about so this is chapter 19, basically from BNSS, which is trial before a court of session. And this section 248 has a title saying the trial to be conducted by public prosecutor. So we're talking about the criminal laws here. So the trial has to be conducted by the public prosecutor. In every trial before a court of session, the prosecution shall be conducted by a public prosecutor. Okay. So, so basically, public prosecutor is somebody, we know that already, that he is an officer of the court who is responsible for representing the state and in all the criminal proceedings. And this particular uh, provision basically is nothing but it's emphasizing that what is the importance to have a trained legal professional to oversee prosecution in the serious cases which are tried in the court of the session. And it cannot be just left with anybody, but a properly trained person has to be there to take care of the matters in the session court, because these are very serious things which are on stake on in terms of for the state also and for the accused as also. And that is why it has gotten history also from the very beginning of the legal practices, which how it started in India. It's at point of time was not even run by somebody who was a lawyer. But over time, when we configured the proper laws and the proper procedures for the courts, and when we over time, moved into the criminal court management, etc. So then this is something which over time has become far more matured also. And it includes uh, the criminal laws are a matter of something which is a matter of a life and death for people. And that is why this accountability on the shoulder of state is also there behind, apart from the accountability to ensure the citizens are protected. It is also very, very important to ensure that the citizens are protected who are accused as well. And then, as this is serious matter, for the victim also, there should be the right representation. And with the interest of everybody, there should be somebody who is a very trained person. And that is why this role of public prosecutors are there. So this brings in a strong accountability, protection of the rights of all the parties, and consistency in the legal proceeding. Let's move to section 249. So it talks about opening case for prosecution. So when the accused appears or is brought before the court in pursuance of a commitment of the case under section 232 or under any other law for the time being in force, the prosecutor shall open his case by describing the charge brought against the accused and stating what evidence he proposed to prove the guilt of the accused. Now, why this is all required also 249 is because what we have seen earlier is in 232, the magistrate can commit the matter to the session court. That is how most of the cases come to the session court, or any from any other way it reaches to the session court. So the prosecutor shall open this case by describing the charge. What we have seen in last session is charge is very, very important, and it is also something which is to bring the clarity, pace, and the right momentum to the court, but that also protects the right of the accused, and that is why the charge has to be very clearly described, and this is the right of the person also to know for what the person is being charged to, or the persons are charged to. So he has to describe the charge, of course, and then evidences are also required to be described. Otherwise, we know that by procedure, the people cannot be summoned or warranted until and unless even the evidences are listed out. So this is the commencement of the proceeding in the session court, what we are talking about in section 249. And this is what the prosecution, the officer of the court, will start with. So this is describing the charge and outlining the evidence, which include the brief overview of all the evidences that will be relied upon, and which may involve the witness testimonials also, which will be part of it, and the documents, form of evidences, everything basically has to be proposed. So this brings again a clarity in the proceeding. This also following the process of letting the person who is accused to know, or whatever, what are the charges, or the person who is considered culprit already in some special cases, person should also know what charges the state has framed against him and or them. And then the as per procedure, the as per the right of a fair trial, etc., until and unless the judge is not aware of the witness and the other evidences against the person in consistency with the charge, then the summons and the warrant has to be then as required, has to be also framed, issued, sorry. And so that is why this is something very, very important in the opening part, which is a sum of all the procedures we have read until now. In the opening of the case, this is applied. So, for example, we have read in 232 how the case can be committed, then how the charges are framed and communicated, and then what is the role of the evidence and the witness to be listed to ensure the court can operate accordingly after that. Section 250, discharge. Of course. So when the accused may prefer an application for discharge within a period of 60 days from the date of commitment of the case under Section 232, if upon consideration of the record of the case and documents submitted therewith, and after hearing the submission of the accused and the prosecution in his behalf, the judge considers that there is not sufficient ground of proceeding against the accused, he shall discharge the accused and record his reason for so doing. So the accused can prefer to an application for the discharge. Discharge we have studied earlier within a period of 60 days from the commitment of the case under section 232. Now, if upon consideration of these records, the case, the document submitted, whatever the accused submitting with the application, and after hearing the submission of the accused and the prosecution on as a response to the presentation by the accused, the judge can consider that there is no sufficient ground for proceeding against the accused. In that case, he shall discharge the accused and record his reason for doing so, which means the accused will be not required to attend anything further in the matter, and the matter is closed. So the accused is given a right to file an application of discharge. So when the matter is committed to the session court, the person has a right to do this activity. Now we know already from the previous learning that in case of the case under 232 been committed to the session court also, then also meanwhile the bail or other activities, custody, etc., can still be controlled by the magistrate who has committed that matter to the session court. And it's a judicial consideration what we're talking about, that where then if everything is fine, the accused is discharged of the particular matter if there are sufficient and solid grounds around that, and it has to be written by the judge. So, which means that the charges are completely dropped, and due to insufficient evidences or evidences in the other direction or some kind of legal foundation, principles, etc. And then judge has to record the reason. So, of course, this section is also placed at the very right place. If we see the placement of the section also, that once we are communicating to the person in the first place, the public prosecutor is doing that, the court is made aware and everything, evidences has been brought, which is, of course, the case has been brought forward by the prosecution. They have the first right to go back and explain the court what is this about. And then when the accused is coming back and challenging that, saying this is not right and against me and I should be acquitted out of it, in that case, the third right is then given to the prosecution to counter it if it is now countered, and then the judge has to make a decision on the discharge. Until and unless we are not moving this stage, if the discharge is happening, I mean, this doesn't happen in all the matters, but in some matter, if the discharge is possible and it is happening, and then judge is acquitting, then no point in putting the section about further proceeding before that. So that's the reason this placement of discharge section is because of that at the 250. Let's move to section 251, which is now framing of the charges once again. So now in this, we have read about the framing of the charges, how it has to be done, what is the form of the charge from that perspective. We have seen that it has to be clear, it has to give in following reasons, it has to give all the proper evidences, date, time, geography, etc. That was from the perspective of the design of that particular charge, technical. Now we see from the session perspective, the framing of the charge in 251, which subsection 1 says, if after such consideration and hearing as aforesaid, the judge is of opinion that there is ground for presuming the accused has committed an offense. Now this can happen at the very first place when the charge is read out, and then the person is probably inquired by the judge, and then or otherwise when the application against the discharge is failing. So either of the cases this will happen. Sub clause A says that the accused has committed an offense which is not exclusively trialable by the court of session, he may frame a charge against the accused and by order transfer the case for trial to the CJM or any other JM of the first class, which is JMFC, and direct the accused to appear before the CJM or the JMFC on such date as he deems fit, and thereupon such magistrate shall try the offence in accordance with the procedure for the trial of warrant case instituted on a police report. Now, in this case, when this is a case where the case was committed to the session court, but then after framing of the charges, etc., even after listening, considering the public prosecutor and the accused, mostly public prosecutor, if the judge believes that this is something which is not suitable for session court and cannot be tried by the exclusively by the court of session, and any other court below that can also try that. In that case, it can transfer the case, but then if it will frame the charge against the accused and by order then transfer it to the CJM so that CJM can move it to any JMFC or as per the court procedure, whatever is framed within the court, they can also assign it directly to the JMFC where then further it will be tried. Subclause B says an offence which is exclusively triable by the court, he shall frame in writing a charge against the accused within a period of 60 days from the date of first hearing on charge. So within 60 days, the session court will frame in writing a charge and then it has to be done within the 60 days of the first hearing on the charge. Subsection 2 says, where the judge frames any charge under clause B, which is where it finds it to be suitable for the session court, the charge shall be read and explained to the accused present either physically or through audio, video, electronic means, and the accused shall be asked whether he pleads guilty of the offence charge or claim to be tried. So in that case, once it is finalized, the charge is confirmed, then it will be asked that if he pleads guilty or he pleads to to be tried. So in either of the cases, it's quite logical that it is done that way, that where once it is everything is done, then if the opinion of the on the initial inquiry, etc., by the judge that it is triable by not exclusively by it, which means it can also be tried by some court which is junior to it. In that case, it will pass it on to that, and then if it is triable by the court, then it will frame the charges, and once the charges are framed within 60 days of the hearing of the charge, then it can be read to the and explained to the accused, which we have learned in the previous video, and it can be physically or audio visual also, as BNSS is putting a lot of effort to utilize the electronic media, and then a question is put in forward of the in front of the accused to giving an option of to plead guilty or claim to be tried. So either of the way, this is what happens under section 251. 252, conviction on plea of guilty. So see how beautifully the sections are placed upon each other one by one. So now the conviction on plea of guilty, the very first part in the subsection 2 of section 251. So if the accused pleads guilty, the judge shall record the plea and may, in this discretion, convict him thereupon. So basically, this is the recording of the conviction on the plea of guilty. So when the person is recording the plea that he pleads guilty, and the judge is required to record this particular pleading in detail, because then this is very, very important part where the accused is admitting of his guilt, and then it says the may in his discretion convict him thereupon, because it's a judicial discretion now again in place. It just cannot happen that you plead guilty and you will be punished. Then judge might also want to have some clarification in later stage also, that he can actually commit it for a trial also. So after recording the guilt, the judge has to, in discretion, to convict the accused based on the admission, where it is very straightforward and it's not very difficult for the judge to understand it is indeed the case, or exercise the discretion to consider the context and circumstances surrounding in the plea, and the conviction is according to that, or it is good for integrity of the judicial process and purpose. Otherwise, it can be still proceeded for further stages into the matter where the judge is not convinced that this is something which is still bringing out the correct facts with all the details, whatever is expected in this particular matter. So it's a judicial discretion given. That's why here, because there might be cases where the accused pleads guilty, but it is not very clear to the court on or what he or on why that person will plead guilty, and does it look something which is still explaining us the all the dimensions of the matter. 253 talks about the date for prosecution evidence. So in the accused, if the accused refuses to plead guilty or does not plead or claims to be tried or is not convicted under Section 252, the judge shall fix a date for the examination of the witness. So this is the situation when the judge is not uh, moving just with the conviction after plead guilty, and he wants the examination of the witness to happen after that. So then the judge will fix a date for examination of the witness and may, on the application of the prosecution, issue any process for compelling the attendance. So any kind of summons, warrants, or both together, etc., whatever we have studied earlier, has to be um, issued to compel the attendance of the witness or the production of any document or other things. So all those things are done after that. So which is the scenario of no plead or claim to trial. In either of the case, Section 253 becomes applicable, and then judge has to put a next date for the witness examination, etc., and issue the process for the witness in the documentation, whatever is required to make that possible. And this is something which is now is the process is set in motion. 254, evidence for prosecution. Now, when the date was fixed, so on the date so fixed, the judge shall proceed to take all such evidence as may be produced in support of the prosecution. So judge will proceed to take all such evidences, provided that the evidences of a witness under this subsection may be recorded by audio, video, electronic means. Maybe. So subsection 2 says the deposition of evidences of any public servant may be taken through a audio, video, electronic means. And the judge may, in his discretion, permit the cross-examination of any witness to be deferred until any other witness or witness have been examined or recall any witness for further cross-examination. So what it says is taking of evidence is what is the subject of this section 254, and on the date, so the date, the judge will proceed to take all such evidences, whether it's a witness or it's a document, etc., in support of the prosecution. But then the evidence of the witness can also be recorded by audio, video, electronic mean, which is also okay to do. That is what it says. Subsection 2 says, again, for the public servant also, the deposition of evidence of any public servant may be through audio, video, electronic mean also. Maybe. And if it is judge, it's a discretion. Wherever the word maybe is there, it's a discretion of the judge. And the judge may, in his discretion, permit the cross-examination of any witness. So the judge may allow a cross-examination of any witness to be deferred until other witness or witness have been examined or recall any witness for further cross. So the judge, it's purely discretion of the judge depending upon how the proceeding happen, that he may allow or he may ask to wait for any cross-examination. That flexibility is something which is provided under this section to case under the discretion of the court, when the judge either will allow the cross-examination of witness to happen immediately or deferred until all the witnesses have been examined first. And this flexibility can basically help in ensuring that the cross-examination process is orderly and does not disrupt the trial flow. Sometimes it is okay to listen all the similar kind of witnesses first, all of them. Say, for example, on the same subject, there are 5 witnesses. And if the cross-examination can start immediately in between, then it might cause to disrupt the trial of the flow of the trial. So in that case, it is normally allowed once all the witnesses of the same subject are already heard. So the judge may recall any witness also for further cross-examination if required. So once the cross-examination has happened after this deferment, or it is happening at the just after when the examination has happened of that particular witness. But in either case, it is also a discretion of the court to recall any per witness for cross-examination and a number of times. This provision which is given ability to the court to ensure that if any ambiguity is there in the delivery of the justice, that can be taken care of. So this is an efficiency-based evidence collection where uh, it is an option to record or for public servant to depose also in terms of audio video electronic means, and the judicial discretion is strongly applied in terms of when the cross examination will be allowed, and the basic principle which governs that is it can should not cause any disruption to the current running proceeding. Now, if after taking the evidence of the prosecution, examining the accused, and hearing the prosecution and the defense on the point, the judge considers that there is no evidence that the accused committed this offense, the judge shall record an order of acquittal. So that can also happen, even in the case where somebody has plead guilty, and the judge is of the opinion it is not the case. And the judge, in either of the cases where the accused does not pleads guilty or goes for a trial, or the accused pleads guilty and the judge is not satisfied, in all those cases, the witnesses have been brought in, and if the taking the evidence from the prosecution, examining the accused and hearing the prosecution and the defense on the point, both the advocates, the judge considered that there is no evidence that the accused committed the offense, then the judge shall record an order of acquittal of that particular person, which means after all those things, hearing both the side, the judge will, on the subject of lack of evidence against that particular offense, what is the person is accused of, it could happen. So recording an order of acquittal will happen after that with all the details the judge has to give. So if you see every point, it is being safeguarded, even to the accused is also safeguarded, because in spite of pleading guilty, there might be a situation where the accused might come acquittal. This can happen in the scenarios where somebody is taking a moral responsibility or maybe emotional responsibility of certain things, but the law has to validate things where it is actually legally applicable that to that person or not. So the defense itself, which is towards saving of the accused, is inbuilt in the system where in spite of even pleading guilty, it's a discretion of the court and application of the mind of the judge in the court and application of the basic principles, etc., observation by the judge, and in any kind of doubt by examining the witnesses, etc., listening to the examining the accused after that, and hearing the prosecution and defense on the point, the judge can still acquit the person. So under section 255, this is a very strong section around the fair trial process, where in spite of the person himself or herself calling themselves self-incriminating and calling themselves guilty, this is something which comes to the rescue of the person. Because in that case, it is not something which was actually a crime which has happened with by the hands of the person. It is just a mere self-incrimination. Section 256, entering upon defense. Now, where the accused is not acquitted. Now, until now, when the evidences were heard and the judge believes the person is not acquitted, and he shall be called upon to enter on his defense and adduce an evidence he may have in support thereof. Now, as the person is considered to be somebody where the trial should begin and forward to continue, sorry, the trial should continue to examine further, that he is also given a chance to enter on his defense and now adduce any evidence he may have in support thereof. So if the accused puts in any written statement, the judge shall file it with the record, which means a copy can be also be taken by the defense. And subsection 3 says if the accused applies for the issue of any process for compelling the attendance of any witness or the production of any document or thing, the judge shall issue such process unless he considers for reasons to be recorded that such application should be refused on the ground that it is made for purpose of vexation or delay for the defeating the ends of justice. So in that case, it's a also the defense basically is a responsibility of the advocates, basically the people who are standing for these people. So this is where if they are able to compel apply for any compel any attendance of any witness or document, etc., and they're able to compel that in the minds of the judge also, that this is something which is very, very important and not just for the sake of vexation or delay or etc. etc. Then only the judge will allow that, which means also indirectly that on grounds of, if somebody, some advocate in subsection 3 who is in defense and filing an application for compelling the attendance of a witness etc., and he is not able to put the right grounds for that, it is very, very much in discretion of the judge that if just an application is made without any reason, then such an application could be declined, turned down, and in case of any such appeal, we have seen a lot of people make such appeal also, going ahead on the such impugn order by the such session court, then that might also be sustained by the higher court, because whatever is very, very important here is subsection 3 is a very key element for the defense, where they want to present their evidences or in terms of documents or witnesses etc. It can only be accepted if a strong reason is given why it is something which is important, and it is not just for defeating the end of the justice, some kind of trick and ploys are being used. So this is a process for the defense where it starts, and it's a very, very pivotal stage of the defense where it makes a lot of difference if the defense lawyer is able to get this permission to call upon their relevant witnesses and production of documents, etc. So this is a very, very key stage for the defense. So when we have what we have right now on record, we have the charge, we have all the documents from the police, then we have all the other applications made by now, and then we have a evidence from the prosecution side. Now we have permission to get the evidences from the person who is accused also, who is not acquitted. And then this is also on record now once it is allowed. Now everything is in place. What do we do now is the argument. Now it reaches to the stage of argument. That is what is shown in all the Bollywood and the Hollywood movies. So that stage you come here now in arguments. So when the examination of the witness, if any, for the defense is complete, the prosecutor shall sum up his case, and the accused or his advocate shall be entitled to reply. So provided that where any point of law is raised by the accused or his advocate, the prosecution may, with the permission of the judge, may make his submission with regard to such point of law. So basically, this is something which is the stage of argument, and this is something which comes after all those stages which has happened, and the public prosecutor's role is also listed here. So once the defense has completed the examination of its witness, so they have done all the examination of its witness. So the defense has completed examination of its witness, which is examination in chief, and the prosecutor is taken with summing up the case. This involves the presenting a final overview of the recap of the prosecutor's argument and evidences, highlighting key points that support the charges against the accused. And summation serves the consolidate the prosecutor's case before the court may make a decision. But following the prosecutor's summary, the accused or their advocate has a right to reply. And this reply is an essential component of the defense's opportunity to then address the prosecution's final argument and rebut whatever the point has been raised by, and reinforce their stance on the innocence, on mitigating factors for the accused to mitigate those particular points which are raised by the prosecution, because prosecution will always point towards claiming defeating the point of the defense and the witness, and will try to bring the person to conviction. So a rebuttal is something which is happening after this stage. And if during the reply to the reply, so while the reply is being filed, if the accused or their advocate brings up any point of law, which is the prosecution may seek the court, then the prosecution has to seek the permission of the court to make a further submission specifying, addressing that legal point also. Then why this is all exercise is being happening, because then the court's responsibility to ensure that everything is happening beyond any doubt, and the person is not prosecuted without giving an opportunity, even after once the defense has prosecution has summarized their argument and all the arguments against the person and to request his conviction, then at that stage also rebuttal is allowed, and if any points of law is raised, all those things has to be addressed by permission of the court. By this a permission of the court, because some of them might be directly accepted by the court also if possible, and the court might not seek any further clarification for the from the public prosecution. So please understand, in spite of the public prosecutor being there, who is supposed to be somebody who is upholding the process and supporting that to the honorable court to run it with the right process to ensure the legal proceedings are running as it has to be run through a trained hand. But then, end of the day, the discretion is in hands of the court on, and it stands and sits above the public prosecutor's discretion also, where they cannot just go ahead and challenge anything which is not permitted by the court. So the prosecution will seek the court's permission to make any further submissions, and specifically addressing that those legal points which are raised. So they have to be to the point on that. Now, this is something which is a complex legal issue which are thoroughly debated and broken into smaller chunks, and then consideration, allowing for a just resolution based upon a comprehensive understanding of the law. So every smaller point is discussed and understood through a comprehensive understanding of the law and the procedure, etc. So this is nothing what is happening through argument. What does happen with the argument, the responses, the rebuttal, everything which comes under arguments? What do we do in the courts with the arguments? Argument is nothing but it's a comprehensive review by both the parties of the charges, the points brought forward by the prosecution, and the rebuttal and its responses. So everybody is whatever doing is nothing but a comprehensive review of the situation, which will allow both the parties to summarize that their case and address each other's argument. And this is something which will ensure that the judge receives a well-rounded perspective, and which is comprehensively reviewed and brought forward to the judge to promote a equitable and informed judgment. That is why the arguments happen. So this is also a part of a legal fairness, this section, which is not allowing only the one side to talk. It allows the both the parties to talk and challenge each other. Of course, under the limits and procedures of the law, but then that is very well allowed. And every stages and every point, if you see, the application of judicial oversight is added, where the final decision comes from the judges depending upon how they are convinced and if they are allowing that particular step to happen or that particular submission to happen or not. So arguments are nothing but a comprehensive review by both the parties to ensure that the judge will understand the whole perspective and in the equitable manner. Section 258, judgment or acquittal of conviction. See how beautifully every stage, like a flow chart in the CRPC, in the BNSS is described, where this happens, then yes or no. This happens, then yes or no. That kind of flow chart and the decision network is applied. So now at this stage, what can happen? And now always the first place is given to acquittal and such kind of things. So now in this case, judgment of acquittal or conviction, either of that can happen, yes or no. So subsection 1 says, after hearing arguments and point of law. So everything is done. Now the judge shall give a judgment in the case. So as soon as possible, within a period of 30 days from the date of completion of the arguments, which may be extended to a period of 45 days for reasons to be recorded in writing. So why this is again done? Because this is something which is a matter of life and death for the person, and we know the judgments are also based upon the lot of elaboration and details which have been brought forward to the court, plus there might be some conditions also put into that particular judgment. So all those things has to be thought of properly. With all the cases on the same board, the judges might take some time to finish it, and that is why they have been given a time that within 30 or within 45 days, depending upon the proper reasoning in writing. And subsection 2 says, if the accused is convicted, so the judge shall, unless the proceeds in accordance with the provision of the section 401, hear the accused on the questions of sentence and then pass sentence on him according to law. So this is something which is talking about the delivery of the judgment. So, after the judge has heard all the arguments, the comprehensive review of the matter has happened. And under the procedure, given the procedure, it all happens. And from both the parties, it is done with any of the point which is raised in the previous section we have seen, and then they are required to give a judgment on the case. Now, the judgment must be provided as soon as possible within the 30 days or 45 days, depending upon what is the reason to be given for that. And sentencing procedure is given after that. That in case if the person is acquitted, then absolutely fine. The person will be acquitted, and probably with sometimes some conditions are also given, or some precautionary lines are also given, that you know uh, sometimes the acquittal will happen fairly because the person has a zero evidence against him for that particular offense, or sometimes acquittal may happen considering that it was a first time offense, something very, very light, and a person can be given a chance, second chance. So in that case, there might be some conditions written there that do not do this again and blah blah blah, all those things. I mean, he might be asked to file some kind of document to the court confirming that he has learned the lesson and would not do it again. So that will in future again go against him very strongly if he is found committing the same thing. So these things are also in the acquittal. In conviction, so if the accused is found guilty and convicted, then the judge is obliged to hear the accused regarding the obligated to hear the basically accused regarding the sentencing matters unless they choose to follow the procedure outlined in section 401, which we'll see later. This is a critical step as it provides the convicted individual an opportunity to present any mitigating factor, personal circumstances, or pleas for any leniency before the sentencing. So still see, there is still an option given that in spite of the person being convicted also, any kind of leniency, any kind of personal circumstances are still heard at that stage. And following this hearing, the judge will then pass a sentence according to the law that is appropriate for the convicted offense. So whatever last chance is also given to the person who is convicted now. He is no more an accused. He is somebody who is convicted now. His guilt is proved. But still at that stage, law again becomes considerate on human values to go back and before giving the final sentences to the person, the final hearing is done to understand his personal circumstances, etc., and any request for leniency. Say, for example, person is convicted for a term of 15 years, 20 years, or some kind of death sentence, etc., etc., or maybe 5 years also, 10 years also, 7 years also. Basically, session court, then it's a higher sentence cases which will come. The person might come back and request for some leniency to acquit him completely or give him some chance, to some lesser number of years of sentences, etc., etc. So all those things, whatever plea the person can make is heard and then sentence is finally given. Now, in this case, what is also important is section 259, which talks about the previous conviction. So in case where there is a previous conviction is charged under the provision of section 7 of 234. We heard that while filing the charges, a previous conviction could also be added in the charge. We have seen it in the last class. And the accused does not admit that he has been previously convicted as alleged in the charge. The judge may, after he has convicted the said accused under 252 or 258, take evidence in respect of the alleged previous conviction and shall record a finding thereon. This is also something which is part of 258 as well. So, provided that no such charge shall be read out by the judge, nor shall the accused be asked to plead thereto, nor shall the previous conviction be referred to the by the prosecution or in any evidence adduced by it, unless and until the accused has been convicted under 252 or 258. So this is basically context from the previous conviction which is described here. So when a previous conviction is relevant to the current charge, then particularly as in section 234, the accused denies having such a conviction. This section outlines the next step. So what is the next step? The evidence of the previous conviction has to be there. So if the accused does not admit, the judge will permit to take an evidence regarding the alleged prior conviction only after the accused has been convicted under 252, which is guilty plea, or 258 judgment after the trial. In either of the cases, The judge will look for a evidence around that also. This approach will ensure that the focus remains on the current charge until a conviction is secured. So this is something very, very important. And then the recording finding has to be recorded. So after hearing evidences about the previous conviction, the judge is required to record the finding regarding the matter. And this is something documentation which is crucial for judicial record and may impact sentencing or implication for future cases. Because laws has to be lenient, but it has to be stringent for repeated offenders. Restrictions on the mentioning previous conviction is also mentioned here, where the provision includes that the strict limitations is there on how previous convictions can be discussed prior to the current conviction. So the judges are not allowed to read the charge related to the previous conviction, and the accused cannot be asked to plead to it because it's a previous conviction. And the accused cannot be asked to plead to it, and the prosecution cannot refer to the previous conviction until the accused has been convicted for the current offense. So until he is not convicted, that should not be an influence, and this protects the undue prejudice to or the influence of the past conviction on the current legal proceeding. So until and unless the person is not proved guilty and convicted, it cannot be mentioned. There is a bar on mentioning such kind of previous conviction to it, so that there is no kind of prejudice which is happening to the accused, or in such that case it is not derailing the current thought process of the matter. So it has to be in spite of present being warded off or cordoned off from any impact of the previous one, and the only current case has to be seen in the light of the current witnesses and the current documents, etc. And once it is finalized and then a guilt is proved and the conviction is happening, then that could be brought in for an additional reinforcement of ensuring that this person is convicted previously also and now also, and the prosecution can plead a stronger punishment for the person depending upon that. And that is why it has to be used very cautiously, the previous conviction. That is what the section says. It is one side, it is being used to ensure the repeated offenses by the same person is also something which is considered, but it is not touched until the person is proved guilty in the current matter. It is no point in doing that. If the person is not proved in the current, see the reverse matter, reverse situation, the person is not proved guilty and he is acquitted, or he is somebody who is uh, discharged at the very initial stage only. There is no point in talking about the previous conviction because it is the current stage and the current crime or the current offense allegation on which the court should have the focus and nothing beyond that. Now, section 260, procedure in case instituted under subsection 2 of section 222. So, a court of session taking cognizance of an offense under section 222(2) shall try the case in accordance with the procedure for the trial of warrant case instituted otherwise that on a police report before a court of magistrate. Now, provided that the person against whom the offense is alleged to have been committed shall, unless the court of session for reason to be recorded, otherwise directs be examined as a witness for the prosecution. Subsection 2 says, every trial under this section shall be held in camera if either party thereto so desires or if the court thinks fit to do so. Number 3, if any such case the court discharges or acquits all or other any of the accused and is of the opinion that there was no reasonable cause for making the acquisition against them or any of them, then it may be by its order of discharge or acquittal direct the person against whom the offense was alleged to have been committed, other than the president, the vice president, or the governor of state of the administration, or the administrator of the union territory, to show cause why he should not pay compensation to such accused or to or each or any of such accused when there are more than one. If any such case the court discharges or acquits all or any of the accused and is of opinion that there was no reasonable cause for making acquisition against them, then this is subsection 3. 4 talks about the court shall record and consider any cause which may be shown by the person so directed, and if it is satisfied that there was no reasonable cause for making acquisition, it may, for the reasons to be recorded, make an order that compensation to such amount not exceeding 5,000 rupees that it may determine be paid by such person to the accused or each of or any of them. And the compensation awarded under subsection 4 shall be recovered as if it was a fine imposed by a magistrate. Subsection 6 says, no person who has been directed to pay compensation under subsection 4 shall, by reason of such order, be exempted from any civil or criminal liability in respect to the complaint made under this section. So, whoever is paying this compensation shall, by reason of such order, be exempted from any such particular liability under the complaint made under this section, provided that any amount paid to the accused person under this section shall be taken into account in the awarding compensation to such person in subsequent civil suit relating to the same matter. Subsection 7 says, the person who has been ordered under subsection 4, this one, to pay compensation may appeal from the order insofar as it relates to the payment of compensation to the High Court. And subsection 8 says, when an order for payment of compensation to an accused person is made, the compensation shall not be paid to him um, before the period allowed for the presentation of the appeal has elapsed, or if an appeal is presented before the appeal has been decided. So 260 is a comprehensive section which talks about the trial procedure in the subsection 222, which is referred in the subsection 2 of the subsection 222, basically. So defamations and in-camera trial is something which is given that it should be held in camera if the either party desires to, and if the court fits to do so. Then subsection 3 talks about the discharge of the or acquittal considerations, whatever happens in that situation. If the court discharge or acquits the accused and finds that there was no reasonable cause for bringing accusation, it may direct the complainant to show cause why they should not pay compensation to the accused. And this is something which is a safeguard against the frivolous acquisitions. That is something which is given. So by its order, discharge direct the person of against whom the offence was alleged to have committed, other than the vice president, etc., to show cause why they should not pay. Why? We have seen that this is something which can be done through the state decided framework GR process through the public prosecutor and by a court. So the state cannot sue itself. So subsection 3 is example of that also. So recording and considering the cases subsection 4, the court must document any explanation provided by the complainant regarding the accusation, and if it concludes that there was no reasonable cause for the accusation, the court may order compensation to be paid to the accused up to limit of 5,000 rupees. And this is something which is component of the section which promotes the fairness of the judicial process, ensuring that wrongful acquisition can lead to repartitions. Subsection 5 talks about the compensation which is awarded under this section is treated as a fine, which is in all the cases. And subsection 6 talks about the continuation of the liability. So basically an individual directed to pay compensation due to a lack of reasonable cause for making an acquisition does not escape any civil or criminal liability associated with the complaint made, and this is ensured that the accountability of the complainant remains intact. So no person who has been directed to pay the compensation shall by reason of such order be exempted. So they do not escape the civil or criminal liability through the complaint what they have made. And additionally, if compensation is awarded to the accused under this section, it is considered any subsequent civil suit related to the same matter. So it can be considered. And this helps to prevent the double jeopardy and ensure that all the factors are considered in related legal proceeding. It will be automatically applied there also. The same. He or she need not go ahead and prove it again. And right to appeal is given in subsection 7, of course, where the individuals who are ordered to pay compensation, they have right to appeal this order in the High Court. specifically regarding that the compensation aspect, basically. And this provision upholds the principle of justice by allowing for judicial review also in the compensation decision, thus providing avenue for the individual to contest the unfair financial burden, although it is only of 5,000. Then there is a timing of the compensation payment, which is described in subsection 8, which talks about the section is confirming that an order for the compensation, when it is made, the payment must not take place until the time allowed for the filing of an appeal has elapsed. Otherwise, the situation would be complex. And if an appeal is filed until that appeal has been resolved, this prevents any immediate financial repercussions that might occur while the order is still under review, and the fairness of the judicial process, which is quite natural. So this takes us to the last section for that particular chapter. So chapter 5 we have completed. So chapter 5 was trial before a court of session and sections 248 to 260. Now we move to chapter 6, which is trial of warrant cases before the magistrates based on the police reports and other than police report. So these two types of cases, warrant cases before the magistrates, and then the conclusion of such trials. So we'll start from section 261 to 266 about the trial case or trial of warrant cases before magistrate based on the police report, and then on other police report on 267 to 270, and then conclusion of the trial from 271 to 273. So basically, from the BNSS perspective, what we are reading is chapter 20, which is trial of warrant cases by the magistrate, and its subsection ABC, which is case instituted on a police report, case instituted otherwise than police report, and conclusion of the trial. So this is a whole chapter 20, which is subject of chapter 6 of this syllabus. So section 261 talks about compliance with section 230. So, when in any warrant case which is instituted on a police report, so this warrant case is instituted on a police report, and the accused appears or is brought before a magistrate at the commencement of the trial, at the start of the trial. Commencement means start of the trial. The magistrate shall satisfy himself that he has complied with the provisions of section 230. What is 230? Where all the documents which are not requested and considered by the magistrate to be hidden on request of the police, all the documents like FIR, charge sheet, and all other such confessions, etc., a copy has to be provided to the accused. So, in any warrant case instituted on a police report, as this is on a police report, the accused appears or is brought before the magistrate at the commencement. The magistrate shall satisfy himself that he has received every such document at the very start. So this is a very important compliance which has to be completed on the rights of the accused, and which the whole of the fair trial process is one of the very important uh, pillars on which it is standing, the fair trial. So importance of the section 230 is something which is called out in this section 261 when the such a case is commenced in front of any magistrate. And in consequence of non-compliance, then the 230 has, if it has not been made, the magistrate must take an appropriate corrective action in this case, which should including the postponing the trial until that document is served to the accused, so that the accused has enough documents, etc., with him to ensure that his rights are not taken away and he is able to prepare for the right defense. So this is a judicial responsibility which is shown by 261, that with very responsibly, the court is first at the very first early stage also looks into the equity and the fair of the trial and ensure that the procedural compliance are made in that direction and protecting the right and efficient creating an efficient trial process around that. Section 262 talks about when accused shall be discharged. We see the same pattern, right? It's logically the same. So when the case is presented, when accused shall be discharged. So the accused may prefer an application for discharge within a period of 60 days from the date of supply of copies of documents under section 230. So when it is supplied within 60 days, the person can apply for the discharge. And if upon considering the police report and the documents sent with it under section 193, which is sent to him, and making such examination, if any of the accused, so that is the charge sheet, and whether physically or through audio, video, electronic means as the magistrate thinks necessary, and after giving the prosecution and the accused an opportunity of being heard, the magistrate considers the charge against the accused to be being groundless. He shall discharge the accused and the report and record his reason for doing so. So similarly, what we have seen in the session court, so application for a discharge can be presented within 60 days with all the evidences, etc., all the documents supporting it. So consideration of all the evidences, what is there, all the police report, and conducting the examination of the accused, listening to them physically or audio video, whatever is suitable and the magistrate deems fit, and reviewing the evidence and argument presented by both the parties. Magistrate will go ahead and might be might believe if he believes the accusations are all groundless, etc., he shall discharge the accused and record his reason for doing so. So this is something, a very early stage, a test which is done to ensure the case is not proceeded, and the person who could be discharged, the case is not also under the judicial oversight, ensured that it is challenged and discharged at that point of time. This is again also saving the time of the courts also for not engaging in unnecessarily into the matters which could be discharged fairly at the very early stage. Now, similar pattern 263, framing of charges. So, if upon such consideration, examination, if any, and hearing a magistrate is of opinion that there is a ground for presuming that the accused has committed an offense triable under this chapter, which such magistrate is competent to try it, which is in his opinion should be adequately punished by him, he shall frame in writing a charge against the accused within a period of 60 days and from the date of first hearing on charge. And the charge shall then be read and explained to the accused, and he shall be asked whether he pleads guilty of the offense charge or claims to be tried. What if the magistrate believes that the magistrate is not competent to try in the subsection 1? He will commit the matter to the higher court, which is the session court. Or in case the session court, when it is committed, and the session court again, under the judicial oversight and the discretion, if it feels that no, it was not something which was in the subject of session court, it can again send it back to the same court. So grounds for framing of charges is basically discussed in this section 263, and which is depending on the evidence and initial examination, etc., the framing of the charges, the selected offense must be one that the magistrate is competent or not. That is something first validation they will do. If it is something of higher order, they will commit it to the higher courts, which is the session court in this case. And the magistrate concludes that all the conditions are met because uh, it is competent to try, nature of the offense is within their jurisdiction, etc., etc., and not above or below, then the magistrate will, after both the considerations are met, then the required to frame a written charge. So in both the cases, session also we have seen, as by the rule of the charge also we have seen that it has to be written, but within 60 days from the date of the first hearing, and the timeline is critical to ensure that the legal process is giving appropriate time also and not too much of time also. Subsection 2 is talking about then the basic compliance, where the charge, when it is framed, it must be read to the accused and properly explained. It just cannot be read verbose, that you just read the sentences. It has to be explained also, and the person is given opportunity to ask question and try to give an opportunity to understand also, so that the accused is fully informed of the specific allegations they are facing. And following the explanation, the accused is asked then they plead guilty or they claim a right to trial. And this is something which is a response which is asked from the accused, and this is something which is essential for establishing the accused position in relation to the allegation, and an opportunity given to him also. to either way, to plead guilty or to, if the person believes this is necessary for him to establish his rights, claim to be tried also. Section 264. Same pattern. If the accused pleads guilty, the magistrate shall record the plea and may, in their discretion, convict him with thereupon. So here also, same pattern, same thing, because this is a judicial process pattern. It will be or similar. So on conviction can happen if the person pleads guilty, but then it's a judicial discretion again, that if the accused acknowledges the guilt also, the magistrate may proceed with the conviction without requiring any further evidence or witness testimony to establish the guilt, or they can give a conviction right away, which is a efficiency and protection of the rights also. In spite of pleading guilty also, the person might be later point of time discharged or acquitted, because the court might have seen the situation otherwise by examining the witnesses. So evidence for prosecution 265 is the next section, where the subsection 1, if the accused refuses to plead or does not plead or claim to be tried, or magistrate does not convict the accused under 264, the magistrate shall fix a date for examination of the witness. Now, he is refusing or does not plead or claims to be tried, provided that the magistrate shall apply, such as apply in advance to the accused the statement of witness recorded during the investigation by the police, which is the requirement of the section 230. Now, the magistrate may, on the application of the prosecution, issue a summon to any of its witnesses directing to attend or produce an document. So we have discussed this in session case also, subject of session court also, similar thing. On the date so fixed, the magistrate shall proceed to take all such evidence as may be produced in support of the prosecution, and provided that the magistrate may permit the cross-examination of any witness to be deferred until any other witness have been examined, recalled. We just talked about in the same video at the start. And provided further that the examination of a witness under this subsection may be done by an audio video electronic means at the designated place to be notified by the state government. So that is a procedure given for electronic means for examination. So basically, it determines the trial procedure in the subsection 1, where the if there this is a condition where the guilt is not considered or proved at the initial stage, the magistrate is required to fix a date for examination of witness, and an advance notice of witness statement, etc., has to be issued. Issuing summon for the witness, etc., for the witness at the request of the prosecution will happen, because they are examining the prosecution case first. So that also is something which is very, very much part of this section. And then taking evidence, where on the designated date, the magistrate will proceed to take the all evidence present in support of the prosecution case, and this is a critical phase, as the witness has to testify and evidence is submitted. And the cross-examination flexibility is also given under this section, where, as we discussed in the previous session subject, that either to be done at the moment when the examination of those people are being done by the prosecution, or can be set for later, or maybe even the person could be recalled again for the cross-examination, etc. And there is an electronic mean of examination which is also allowed, where the examination of witness can conducted through audio-visual electronic means at location designated by the state government, etc. And this modern approach is also given in BNSS, as I mentioned, in multiple instances. So this is something which is similarly in any of the proceedings. Now, evidence for defense. Now, the accused shall then be called upon to enter upon his defense and produce his evidence. And if the accused puts it in any written statement, that is also put into the record. We see seen exactly in the session also, session subject in this same video. In the accused, after he has entered upon his defense, applies to the magistrate to issue any process for compelling the attendance. Now, his attendance of witnesses or any document, etc., and attendance of the witness for the purpose of examination or cross-examination, examination, etc., or the production of any document, etc., the magistrate shall issue such process. The magistrate is facilitating. So what is the role of the courts here? The magistrate or the judge in the session is they're facilitating, supporting, while validating also unless he considers the such application is not refused on the ground, it made for purpose of delaying vexation, etc. So, see, the magistrate is or the judges in all these scenarios also help the facilitation, because all the machineries of the court in the support of the judicial process will only run on the order of those person who is the particular magistrate or judge of that particular court. But then what why it is not automatic is, if automatic, this can be used unlimited of time, unnecessary also, and being could be done. An accused can choose to call upon witnesses and documents n number of times, thousand number of times, 5,000 number of times also, quoting any other name, any other document which might not be related to particular matter. That is why there is a judicial oversight is also attached, that everything happens, the court is facilitating, but then it is under the control of the judge, seeing it is not done for the reason which is not relevant to the matter. Provided that when the accused has cross-examined or had the opportunity of cross-examining any witness before entering on his defense, the attendance of such witness shall not be compelled under this section unless the magistrate is satisfied. Now, this is a discretion of the court applied here, where the accused has already cross-examined or has opportunity to cross-examine a witness before entering on this defense. Then such witness shall not be compelled under this section, and provided further that the examination of a witness under this subsection may be done by audio, video, electronic mean also, that is also possible. Subsection 3 talks about the magistrate may, before summoning any witness or any application under subsection 2, which the defense has called, require that the reasonable expenses incurred by the witness in attending for the purpose of trial is deposited in the court, so that they can claim it, the reimbursement from the court. So that those things are also facilitated, because then defense is calling somebody and it might be unfair for the person to come and unjust for the person to come on his or on their expense. So entering upon the defense, the evidence for the defense, what happens and how it is happening, the basic guideline is given under section 266, where the defense can present any evidence they may have, and the fundamental step allows them to counter the prosecution's case. The purpose is of countering the prosecution case, which is their right. And if the accused submits that in written statement also anything, that WS also, as we call in the language of the court, that WS also has to be put on the record, and it will also be give circulated as a copy. Request for witness attendance in subsection 2, it is talked about in the similar lines for this, as we discussed in the same video about the session code, that beginning their defense, if they wish to call any witness examination, cross-examination, produce documents, etc., they can apply it through the magistrate, but then it's the discretion of the magistrate that it is not violating the delivery of the justice by just calling upon somebody, or it is something which is defeating the matter unnecessary, or it is something which is delaying the matter tactics. So this provision further puts a judicial control on those things. Use of audio video technology is also given in the proviso, where it can also be done using an audio video tool, electronic mean. The witness expenses is a very critical thing which is brought in subsection 3, where they might have to put those expenses to be incurred by the witness and which could be claimed. So this is something which is also taking care of those people who are coming to for the deposit for the defense also. So this is something which is about the evidence process over the defense, how the evidence process for the defense runs. Now, 267, where we talk about the evidence. So before that, now, evidence for prosecution. When in any warrant case instituted otherwise than on a police report. Now we have completed the part where the warrant case was issued by a police report. Now let's see the processes further for warrant cases issued otherwise, which is from section 267 to 270. So evidence for prosecution. So when in a warrant case instituted otherwise than on a police report, the accused appears or is brought before a magistrate, the magistrate shall proceed to hear the prosecution and take all such evidences as may be produced in support of the prosecution. Now, the magistrate may, on the application of the prosecution, issue a summon to any of its witness, directing him to attend or to produce any document. So now in this case, this is a warrant case which is instituted otherwise than on a police report. And the accused appears or is brought before the magistrate. The magistrate shall proceed to hear the prosecution and take all such evidences which is produced in support of the prosecution, and they can also issue summons, etc., to the person, to witness who has to come and attend, or any document which has to be produced. So this is which is commencement of hearing in case of a warrant case instituted otherwise than a police report. This section talks about, and it talks about also that the issue of the summon of such witness, document, etc., can happen at this stage. So as usual, we have seen in the previous two examples on the sections, sorry, around session proceedings and the magistrate proceeding in case of the police report. Very similarly here also, when accused shall be discharged. So if upon taking all the evidences referred to in section 267, the magistrate considers for reasons to be recorded that no case against the accused has been made out, which if rebutted would warrant his conviction, the magistrate shall discharge him, and nothing in this section shall be deemed to prevent the magistrate from discharging the accused at any previous stage of the case if, for reasons to be recorded by such magistrate, he considers the charge to be groundless. So grounds for discharge is something which is given here, where the magistrate has taken all the evidences, 267. So this is a matter brought on without a police report, and in that case, the how the court will be appreciated and will be aware of the things is in 267, once they bring in all the evidences, etc., and evaluate. So then if there is a sufficient basis to proceed with the conviction, and if the magistrate determines that the record whatever is presented to under 267, there is no case against the accused that would justify a conviction, or the evidence remains unrebutted, the magistrate is obliged to discharge the accused. The person has to be discharged. And this determination is, which is very crucial in upholding the principle of innocent until proven guilty, and ensuring that the individuals are not unfairly subjected to the trial, etc. And discharge at any stage is also possible. So it doesn't say only after seeing everything. The subsequent subsection also allow the magistrate to discharge the accused at any earlier stage also in the proceeding. So it can be done in the discretion of the court earlier also, not just after all evidences have been taken. So it's not that they have to wait for seeing all the evidences to flow in, all the documents to come in. At any stage, if the judge is satisfied, it's the if he considers to discharge the person and the charges are groundless, the proviso reinforces that the judicial discretion is there to stop this proceeding, discharge the person at any stage before all the uh, any previous stage of the court of the he can consider the charge to be groundless the moment he feels the grounds are uh, groundless. So this is safeguarding the right, the judicial efficiency also, where it is evaluating and getting rid of the unnecessary from the machinery, and brings in a judicial accountability also, because if the person has been to be discharged, the reasons has to be given in detail and in writing by the magistrate. Now we are into section 269, which is procedure where accused is not discharged. So similar section as we have discussed earlier. So if when such evidence has been taken or at any previous stage of the case, the magistrate is of opinion that there is no ground for presuming that the accused has committed an offense triable under this chapter, which such magistrate is competent to try and which in opinion could be adequately punished by him, we shall be writing a charge against the accused. Now, why this is the similar thing where after testing the matter and the evidences, and at any previous stage of the case, the magistrate is of opinion there is a ground for presuming that the accused has committed an offense triable. So he has right under the previous section to discharge the accused at any stage. Similarly, if evidence has been taken and or at any previous stage of the case also. So at a previous stage, he can discharge or he can determine also. The other way is also possible, where the person has actually committed an offense, which is the understanding of the court. The court is satisfied with that. Then the and the two tests are successful, where the court is competent and it is in the jurisdiction of the court, he shall frame in writing a charge against the accused. The very stage, what first stage happens is what? The charge framing. So the charges shall then be read and explained to the accused as the basic necessity, and he shall be asked whether he pleads guilty or has any defense to make. So now he was not discharged or the case was not discharged, consideration of the discharge was done at any of the stage previous. The accused is believed to be committed some kind of offense and the charges are framed, and then the very first opportunity again is given to is first read and explained, and then asked him to either plead guilty or uh, the magistrate should record the plea in that case and his discretion convict him thereon. So if they say, I plead guilty, the conviction will happen. Now, if the accused refuses to plead or does not plead, which always happen most of the time, claim to be tried, or if the accused is not convicted under subsection 3, means the previous situation of plead guilty has not happened, he shall be required to state at the commencement of the next hearing of the case, or if the magistrate for reason to be recorded in writing so think fits forthwith, immediately whether he wishes to cross-examine any, and if so, which of the witness for the prosecution whose evidence has been taken. So we have seen in the previous section also, in this stage, if the cross-examination is done by the defense, they cannot recall that witness later. But this is something which is helping to eliminate the necessity for further running the trial and might be settle the trial at that point of time. And for that perspective, it is again a chance given to the defense to cross-examination of any of the witness brought by the prosecution and whose evidence has been taken. Now, if says he does so wish, the witness named by him shall be recalled, and after cross-examining and re-examination, if by they shall be discharged. So, if they court is okay and allowing that person to be cross-examined, so that person will be recalled, who has appeared as a witness previously for the prosecution and who was examined by the witness by the prosecution in front of the court. The person would be cross-examined, right? If cross-examination happened, and if the prosecution wants to do a re-examination also, in case, then if the court is satisfied at this stage by seeing the cross-examination and re-examination, or only the cross-examination if re-examination does not happen, is not preferred by the prosecution, then in that case, if the court is satisfied at that stage also, they shall be discharged at that point also. So if you see all the necessary forces, all the necessary efforts in the whole process, in all the sections, what we are seeing is always to acquit or discharge the person at every stage. So that opportunity is given multiple times. Even at a post conviction also, the person is given time to give a request for a leniency. Now, subsection 6 says the evidence of any remaining witness for the prosecution shall next be taken, and after cross-examination, re-examination, they shall also be discharged. So the evidence of any remaining witness for the similar condition. And subsection 7 says where despite giving opportunity to the prosecution and after taking all reasonable measures under this Sanhita, so all this thing has been done, if the attendance of the prosecution witness cannot be secured for 5 and 6, which is recalling them for a cross-examination by the defense, and also, if required, a examination if they wish to do by the prosecution, cannot be secured for cross-examination, it shall be deemed that such witness has not been examined for not being available, and the magistrate may close the prosecution evidence for reasons to be recorded in writing and proceed with the case on the basis of the materials on the record. Now, if these people do not appear, these witnesses are not appearing and are not making them available for the cross-examination, then if the attendance of these people cannot be secured for cross-examination, it shall be deemed that such witness has not been examined for being available. So this validity for the examination also is dropped. So framing of charges is the subject of this particular section 269. And the very first subsection is talking about framing of charges in that condition. Subsection 2 talks about the reading and explaining of the charges, which is a natural hierarchy. When we frame charge, we have to explain that also. Conviction of the guilt on guilt plea, if the person has plead guilty, the conviction may happen. And subsection 4 says next step is no plea is entered, then court proceeds. And then it talks about witness recall and evidence in section 5, subsection 5, where they are given opportunity to cross-examine any witness. And taking evidence of the remaining witness is subsection 6, where the trial shall proceed with the evidence from any remaining prosecution witness who will also undergo cross-examination, re-examination, either immediately after the examination or after all the examinations are happened. Then defense have an option to do a cross-examination in either of the cases. And the closure of the prosecution evidence is given in subsection 7, where the attendance of the prosecution witness cannot be secured for a cross-examination despite reasonable effort. In 5 and 6, where all the witnesses and the remaining witnesses are cross-examined, the magistrate may conclude that those witnesses are unavailable and may close their prosecution evidence. So their evidence will be washed out, and the court will then proceed based on the evidences which is already presented and documented. So whatever is remaining, the court will proceed with that, ensuring that the trial can continue without unnecessary delay and those witnesses are eliminated. Section 270. Evidence for defense. So the accused shall then be called upon to enter upon his defense and produce his evidence, and the provision of section 266 shall apply to the case. So whatever was in 266, we read about this in the same video, that will be applicable, and the person is allowed to put a 266 versus whatever was the provision given is applicable here. So prosecution has completed their case and accused is formally required to present their defense. So initial witness, etc. has been done. So this is crucial now. The defense counter starts at this stage. And incorporation of 266 provision indicate that the rules which are there are all applicable here, which is taking care of the rights of the accused. So that is why this is in plain reading, something which is giving an opportunity to the defense to follow whatever is part of the section 266 and evidence for the defense. So they can call upon witnesses, their attendance they can request, audio video technology provision is given, the witness which is coming up, their expenses has to be put in. So all those things replicate from section 266 here. Now we have completed the two sub parts of the chapter, which is trial of warrant cases before magistrate based on police report and other than police report. Now we move to the conclusion of the trial, which is 271 to 273. So how this conclusion happens now in both the cases. So acquittal or conviction, that is the only thing which can happen. So if any case under this chapter in which a charge has been framed, the magistrate finds the accused not guilty, he shall record an order of acquittal. So any case, this is what the magistrate will do. Where in any case, the magistrate finds the accused guilty, but does not proceed in accordance with the provision of 364 or 401, he shall, after hearing the accused on the question of sentence, pass sentence upon him according to the law. And subsection 3, where in any case under this chapter, a previous conviction is charged under the provision of section 7 to 34, and the accused does not admit that he has been previously convicted, as alleged in the charge, the magistrate may, after has convicted the said accused, take evidence in respect to the alleged provision, previous conviction, and the shall record a finding thereon, and provided that no such charge shall be read out by magistrate, nor shall be accused be asked to plead thereto, nor shall the previous conviction be referred by the prosecution or in evidence reduced by it, unless and until the accused has been convicted under subsection 2. So what is this section talking about? In case the acquittal happens, when the charges have been framed, magistrate find the accused not guilty at any stage after the evidence, etc., then the judge can acquit that person. So that is allowed. Now, in case under this chapter, if the magistrate finds the accused guilty, if he is found guilty, and in case of the provisions of the subsection 7 of section 200 the provisions of section 364 or section 401 does not proceed in accordance to that, which is when the magistrate cannot pass sentence, sufficiently will serve, or section 401, which says the order to be released or to release on probation on good conduct or after admonition, he shall after hearing. So in both the cases where it is effective for the magistrate to pass an order and not ineffective and not it is something which is barred, he shall, or making sense, then after hearing the accused on the question of sentence, pass sentence upon him according to law. So if in the sections where he is there is no effect of passing any such kind of, or there is no requirement of passing such kind of order of sentencing, in all the other cases, if he finds guilty, he can pass a sentence which is part of the subsection 2. So establish that accused is guilty and they are obliged to hear the accused regarding the sentencing phase. The sentence will be provided. And subsection 3 says that in case under this chapter, a previous conviction. So that is what we have seen in the multiple chapters where it is allowed to be the previous conviction to be taken in consideration, but then it has to be taken in consideration only in terms of counting witnesses or by the prosecution to ask for a stringent punishment, etc., can only happen once the person is convicted. As I discussed in the same video at the start, this is something which has to be taken to ensure that the fairness of the current trial is untouched by any other thing. And once the person is found not guilty, these things have no effect. But if the person is found guilty, then there is an effect of that the uh, person who was not prejudiced earlier or the trial was not unfairly biased because of that. But then once the guilt is proved, the conviction is then used against the person also, seeing as a repeated offender, and according to that, as any stringent punishment or sentence could be heard. But then please understand, in spite of that, before that, the person will still again get an opportunity where he can go back and uh, talk about the previous conviction or about any leniency before the verdict is provided in the matter. So, previous conviction is alleged and disputed by the accused, the magistrate can consider this claim only after the accused has been found guilty. So, magistrate must take evidence regarding this only post conviction. And prosecution can also talk about only post conviction, not before that. We have talked about this earlier in this same video. So 272 talks about any absence of the complaint. So when the proceedings have been instituted upon complaint and on any day fixed for the hearing of the case, the complainant himself or herself is absent. So it is talking about the situation where the proceeding is instituted upon complaint, not a police report, and the offense may be lawfully compounded or is not a cognizable offense. So the offenses which are compoundable means which could be settled by the parties themselves, or is not cognizable offense where it is not something which is lying in the list of the cognizable offenses. The magistrate may, after giving 30-day time to the complainant to be present in his discretion, notwithstanding anything hereinafter before contained, at any time before the charge has been framed, discharge the case. So in that case, if the complainant itself is not available, a 30-day notice is given. And in the case where it is lawfully possible to compound and is not a cognizable offense, the magistrate can discharge the accused at any time before the charge have been framed. Because if the matter has moved to the stage of charge, which means the court has already taken a consideration of understanding there is some offense which has happened. So this is a lawful compounding and non-cognizable offenses cases. It is definitely possible to discharge the matter, and until and unless any charge not has been framed. Because once charge is framed, which means the process of trial has already started, and which means that the magistrate or the judge has already understood there is some offense which is in picture. So in that case, it is not possible, but otherwise the discharge of the accused can happen in absence of the complainant, and it does makes the take care of the rights of the accused also, because somebody alleging something and being absent himself or herself makes a malified intention or maybe some kind of vexatious complaint which has come, or the intentions are not right because the person, after putting the application, himself herself is absent. Compensation for acquisition without reasonable cause. So, of course, following 272, if any case instituted upon complaint or upon information given to a police officer or to magistrate. One or more persons is or are accused before a magistrate of any offense triable by the magistrate. So whatever we have studied earlier. And the magistrate by whom the case is heard discharges or accused or acquits all or any of the accused and is of opinion that there was no reasonable ground for making the accusation against them or any of them, the magistrate may, by his order of discharge or acquittal, if the person upon whose complaint or information the accusation made is present, call upon him forthwith to show cause why he should not pay compensation to such accused or to each of any of such accused when there are more than one, or if such person is not present, direct the issue of a summon to him to appear and show cause as aforesaid. Section 2, subsection 2 says the magistrate shall record and consider any cause which such complainant or informant may show, and if he is satisfied that there was no reasonable ground for making the accusation, may for reasons to be recorded, make an order that compensation for such amount, not exceeding the amount of fine he is empowered to impose as he may determine, be paid to by such complainant informant to the accused or each or any of them. So this can happen if it is believed that it is completely done, which was not supposed to be done. If it is a mistake which is not something which is of that kind, they can avoid the punishment, the fine also. The magistrate may, by the order directing payment of the compensation under subsection 2, further order that in default of payment, the person ordered to pay such compensation shall undergo simple imprisonment for a period not exceeding 30 days. So if false complaints are made, a simple imprisonment of 30 days is possible if such payment is not done. When any person is imprisoned, subsection 4, under subsection 3, the provisions of subsection 6, which is down below of section 8 of the Bharatiya Nyaya Samhita shall so far as may be apply. So, imprisoned person is imprisoned under subsection 3, sorry, not below, above. So, the magistrate by order, if the compensation is not paying, his person is imprisoned for 30 days. The subsection 6 of section 8 of the BNS shall so far may apply. So, the person who is imprisoned under subsection 3 and the provision of subsection 6 of section 8 will then apply from BNS, which is the things said and done by conspirator in reference to common design. So any kind of conspiracy the person has done, so that punishment can also be applied. Subsection 5 says no person who has been directed to pay compensation under this section shall by reason of such order be exempted from any civil criminal liability. We've seen this in a previous section also in the same video. So they are not exempted from any such liability, provided that any amount paid to the accused person under this section shall be taken in account in awarding compensation to such person in subsequent civil suit also. So double jeopardy is avoided. Subsection 6 says a complainant or informant who has been ordered under subsection 2, which is consider any case where such complaint information show if he has no reasonable ground and fine is something which could be imposed to that person. Has been ordered under subject to by magistrate of the second class to pay compensation exceeding 2,000 rupees may appeal from the order as if the complainant or informant has been convicted on trial held by such magistrate. And when an order for payment of compensation to an accused person is made in case which is subject to appeal under subsection 6, the compensation shall not be paid to him before the period allowed for appeal. So which have seen the previous section also. And the provisions of this section apply to summons case as well as to warrant cases. So 273 is the section which talks about basically summarily the compensation for acquisition without reasonable cause if it happens. We've seen similar situation where it was talking about defamation. So grounds for compensation, the subsection provides a mechanism for the magistrate to assess the address the acquisition deemed baseless and presence of a complainant or informant allowed for immediate inquiry. And if he is not available, they have to be summoned and brought and show caused. Consideration for reason the magistrate given in subsection 2, where the magistrate must evaluate any explanation provided by the complainant or the informant concerning the acquisition. If deemed insufficient, magistrate can impose compensation so causing the balance of justice while discouraging any frivolous complaint. Enforcement of compensation is given in subsection 3, where in case of default, a person could be uh, seriously offended, is ordered to pay such compensation or the undergo simple imprisonment for not exceeding 30 days. Now, civil liability is also given in subsection 5, that compensation is directed. The section also clarifies that it does not absolve the complainant from any further legal consequence of any civil or the uh, uh, to the acquisition, maintaining a clear boundary between the compensation and the liability. Like in the previous section, appeals for the compensation order is also allowed. Timing for compensation is also given, that the can be paid to prevent premature disbursement period to resolving any appeal. So that is why it has to be done after an appeal. An application to different case is also given, that both summon and warrant cases, it is consistently applicable. So this is nothing but to deter any frivolous complaint. Is protecting the accused's right. So chapter 6 we have completed. Now we move to chapter 7, trial of summon cases, such as section 274 to 282. So this section 274 to 282 is chapter 21 of BNSS, full chapter, which is trial of summon cases by a magistrate. Now, substance of acquisition to be first stated in a summon matter. So when the summon matter is starting, so when in a summon case the accused appears or is brought before the magistrate, the particulars of the offense of which he is accused shall be stated to him. See the similar pattern, the similar ingredients has to be there, and he shall be asked whether he pleads guilty or has any defense to make, but it shall not necessary to frame a formal charge, because this is we are talking about a summon case. Provided that if the magistrate considers the accusation as groundless, he shall, after recording reasons writing related, release the accused, and such release shall have the effect of discharge. So immediately that can happen under 274, where the communication of the charges are done right now, immediately. So whenever the accused is appearing, it is important that they are informed of the specific accusation against him, and this is something which is the right of the accused, we know. So any kind of uh, opportunity is given to the accused immediately for any kind of plea for guilty or for defense, etc. And this is very, very important stage. Any formal charge is absent here in case of summon, where the provision indicates that it is not mandatory to frame a formal charge for summon case, which can streamline this purpose of the summon case also to be a very faster and simpler. And this is something which may help the legal proceeding expediently being done. It's a groundless acquisition if the magistrate finds at that point of time. The magistrate can release the accused, and such release can have the effect of a discharge, how we have seen in the related to discharge sections in the previous sections. So immediately after that, the discharge is taken care in the previous section only. If it is not, then conviction on plea of guilty. If the accused pleads guilty, in that case, the magistrate shall record the plea as nearly as possible in the words used by the accused, and may in his discretion convict him thereon. So he will record the plea as closely as the way the person is saying, because it makes a lot of difference from the word choice and the sentence composition. And based on this plea, it's a discretionary authority that he can convict the person. So recording of the plea is very, very important, and a discretionary conviction can happen in this matter. We have spoken about a discretion where he can have a discretion to convict or investigate further. So conviction on plea of guilty in absence of accused in petty cases. So in the cases where conviction of plea of guilty, which can happen in the absence of. So how? So where a summon has been issued under section 229 and the accused desires to plead guilty to be charged without appearing before 102, the magistrate, he shall transmit to the magistrate by post or by messenger a letter containing his plea and also amount of fine specified. So we've seen this earlier also, that in such cases the person has an opportunity to uh, plead guilty on the charges without appearing to the magistrate. So it's a typing error here. It's 102 before the magistrate, and he shall transmit basically uh, through the amount also of the fine. The magistrate may, in his discretion, convict the accused in his absence or his plea of guilty and sentence him to pay the fine specified in the summons, and the amount transmitted by the accused shall be adjusted towards that fine. Or where an advocate authorized by the accused in his behalf pleads guilty on behalf of the accused, the magistrate shall record the plea as nearly as possible in the words used by the advocate, and may in this direction convict the accused on such plea and sentence him uh, as aforesaid. So, when in the summons case, this is a remote plea submission, which is we are talking about. So, remotely the person can plea the summon. So, it is allowed that way. So, where a summon has been issued under Section 229 and the accused desires to plead guilty of the charges without appearing before the magistrate. So in this case, the subsection 1 says that it allows the accused to communicate that their plea without needing to be physically present in court by allowing submission via post or messenger, or uh, the law accommodates individuals who may be unable to attend for the various reasons while still ensuring their legal rights are preserved and legal accountability is also taken care. Discretionary conviction can happen. The magistrate is empowered to convict the accused based on the plea submitted. So, however is submitted in subsection 1, this flexibility basically aims to ensure that the legal process is efficient, especially in minor cases. These are minor cases, reducing the burden on the court system while maintaining justice also. And the section also provides for situations where an advocate which can plead on behalf of the accused, the plea must be accurately recorded, maintaining the integrity of the legal record while still allowing the representation by a legal counsel. So this brings an efficiency in handling petty cases. This also takes care of the right of the accused, which he can exercise remotely also, and also permit them to have a legal representation. So that is how Section 276 is talking about the conviction on plea of guilty in absence of accused in petty cases. Now, procedure when not convicted. Now, if the magistrate does not convict the accused in the previous section we have seen, or section 276 just previous to this, the magistrate shall proceed to hear the prosecution and take all such evidences as may be produced in support of the prosecution, and also to hear the accused and take all such evidences as he produces in his defense. Now see the difference, it is happening immediately and together. And the magistrate may, if he thinks fit on the application on the prosecution or the accused, issues a summon to any witness directing him to attend to produce any document. So only on the application of prosecution application in the same hearing, the magistrate can then hear both the parties, their evidences, or whatever they are being producing, and if they required any such person or document to be produced, such kind of summon and order, any witness, etc. That is something which could be done immediately in the same particular hearing. And subsection 3 says the magistrate may, before summoning any witness on such application, required at the reasonable expense of the witness of the incurred in attending the purpose of trial be deposited in the court. So see, everything is in this matter is happening together. There is no formal structure and date by date such thing happening one after other. It is happening very quickly. The purpose is to do it very quickly. So in this particular case, in the same particular trial, in the same particular date, on the same particular hearing, it is possible both the witnesses, whatever the evidences they have, has to be produced by the defense, etc., and summons could be issued, and such money has to be deposited, whatever in the court for the cost for the logistic for those witnesses to appear, that everything could be done under section 277. So when this is happening, when proceeding with the prosecution, then in that case, this is the witness of both the parties which are to be produced will be taken, and the magistrate can also summon and also receive the monies for the sake of ensuring the cost for the logistic of such witnesses of the defense are sub deposited in the court. So this is the essence of a summon trial. Now, once everything is done, then acquittal or conviction. So if the magistrate, upon taking the evidence in section 277, it was taken in there, and such further evidence, if any, or the summon, etc., whatever been issued, the person comes and the document presented, or he may, of his own motion, cause to be produced, finds the accused not guilty. So any document, etc., which is coming from either of the parties or the court himself or herself has, the court has requested on their own motion, cause to be produced, find the accused not guilty, he shall record an order of acquittal. So very quickly done. While subsection 2 says where the magistrate does not proceed in accordance with the provision of section 364 or 401, which is some cases where it is not important for them to give a judgment or maybe pardon, etc. In those cases, he shall, if he finds the accused guilty, pass sentence upon him according to law. So then immediately a sentence could be passed. Subsection 3 says a magistrate under section 275 to 78 convict the accused of any offense triable under this chapter, which from the fact admitted proved he appears to have committed, whatever may be the nature of the complaint summoned. If the magistrate is satisfied, the accused would not be prejudiced thereby. So his rights are properly taken care. In that case, either in order of acquittal will happen as per subsection 1, or a sentence will be passed, and the scope of the conviction will be that it will allow the magistrate to flexibly to convict the accused of any offense that emerges from the established facts. And this is a significant because it broadens the scope of the potential offenses the accused could be convicted of, facilitating justice even if the original complaint or summon did not explicitly cover that particular offense. So all those things taken care, which may be on own motion of the court, also has been brought in. So it must be ensured that the accused is not harmed or prejudiced by the wider scope of the conviction. That also has to be taken care. 279. Non-appearance or death of the complainant. So if the summon has been issued on a complaint, and on the day of the appointed on the day appointed for the appearance of the accused, or any day subsequent thereto to which the hearing may be adjourned, the complainant does not appear, the magistrate shall, after giving 30 days time to complainant to be present, notwithstanding anything here before contain, acquit the accused. Unless some reason he thinks to proper to adjourn the hearing of the case to some other day. Provided that where the complainant is represented by an advocate or by the officer conducting the prosecution, or where the magistrate is of opinion that the personal attendance of the complainant is not necessary, the magistrate may dispense with his attendance and proceed with the case. So quite logically, in this case, if the person is not, complainant is not available in 30 days notice also, the person could be the anything could be acquitted. The accused will be acquitted, and the provision of subsection 1 shall, so far as may be, apply also to the case where the non-appearance of the complainant is due to his death. So when the person is dead, then also the acquittal will happen in this such petty cases. So requirement for complainant's appearance is very, very important. Adjournment and acquittal is in hands of the judges, magistrate, to ensure if they want to adjourn it, if it looks reasonable to them, or acquittal. It's completely discretion of the court. Consideration of a legal representation, if it is there, then the court can dispense. And the this is extended and subsection 2 into the death condition of the complainant also, where the complainant has died, the section recognizes that the reality that the legal proceeding may need to account for the unfortunate circumstances of the complainant passing, and this ensures a fair process in maintained, and even then the individuals originally involved in the case are no longer able to participate. So subsection 1 is applicable. So protection of accused right, which has happened, it's an efficient proceeding, which is very quick also, and respecting circumstances of the complainant is also done in case if he or she is allowed to represent by advocate or is being represented by advocate or some other officer of the court. Withdrawal of a complaint. So if a complaint at any time before a final order is passed in any case under this chapter satisfy the magistrate that there are sufficient grounds for permitting him to withdraw his complaint against the accused. If there be more than one accused against all of or any of them, the magistrate may permit him to withdraw the same and shall thereupon acquit the accused against whom the complaint is so withdrawn. So at any time before final order is passed, up to that point of time, if satisfies the magistrate that there are sufficient grounds for permitting him to withdraw his complaint, so then it also is with the permission of the court, the withdrawal. So withdrawal can happen at any point of time before the final orders are passed, but then it has to be done on the sufficient grounds that are therefore all the legitimate reasons to allow the person to withdraw. This is also something which is protecting also the complainant also, because there might be undue pressure, coercive pressure on the complainant also, where he might be for something very serious, he is going and withdrawing the case. So then that point of time, the magistrate might inquire. And if everything is fine, then if the complaint is withdrawn, the magistrate must accept if this magistrate is accepting the complaint withdrawal, then they must acquit the accused. And this is something which is protecting now the right of the accused. If the complaint is no more existing, there can't be any complaint. There can't be any trial or any proceedings. So the person will be acquitted. 281. Power to stop proceedings in certain cases. So if any summon case instituted otherwise than upon complaint, a magistrate of the first class or with the previous sanction of the CJM, any other judicial magistrate may, for reasons to be recorded by him, stop the proceeding at any stage without pronouncing any judgment, and where such stoppage of proceeding is made after the evidence of the principal witness has been recorded, pronounce a judgment of acquittal, and any other cases release the accused, and such release shall have the effect of discharge. So this is a section about stopping of the proceedings. So the authority to stop proceeding allows that the magistrate to withdraw from continuing with the case if circumstances warrant it. And this is something which can help prevent any further use of the court resources on cases which were meant may not justify any kind of continuation. And please understand, we are talking about the summon cases, which means we are talking about the smaller offenses. We are not talking about a session trial, etc. And that is why these cases withdrawal is allowed. So recording of reason has to be definitely given by the magistrate to do that, and the judgment of acquittal has to be given. If in such case the proceeding has to stop, then the person who is accused has to be given the benefit of getting a judgment of acquittal. And this particular action will have a effect of the discharge in case of the person who is accused of. So this is effectively discharging him all the acquisitions which were made during this particular proceeding. Power of court to convert summon cases into warrant cases. Now this is also very important aspect, and it makes quite a sense also that in course of the trial of summon case relating to offence punishable with imprisonment for a term exceeding 6 months, it appears to the magistrate that in the interest of justice, the offence should be tried in accordance with procedure for the trial of warrant case. Such magistrate may proceed to rehear the case in that manner provided by this Sanhita for the trial of warrant case, and may recall any witness who may have been examined. So the matter, if it looks like to be put much more emphasized way, much more detailed way, in that case a rehearing could be done, and witnesses could be recalled also, and the case could be then run into, instead of as a summon case, which is done on a very empirical and a very summarized way, the warrant case could be, could be converted into a warrant case. So it is upholding basically the interest of the justice. So it says in interest of the justice. If you see, it appears to magistrate that in the interest of the justice. So in case the provision basically focusing on the principle of the justice, allowing the flexibility in the judicial process in the upwards also. If the severity looks, it might happen prima facie, it might look like something very simple, but then it looks a legal scrutiny far better. And then in that case, for the detailed scrutiny, a warrant case has to be instituted. And in that case, we have studied about warrant case, how it happened will be previous to this, and then it could be converted into a warrant case. A rehearing can happen, and the magistrate can rehear the case in that mode also. So which will allow all the evidence to be re-evaluated, and more stringent procedure will be applied as applicable in the warrant cases, as we have seen, and ensuring that the due process is upheld. While recall of witness, of course, will have to do, because it's a retrial which is happening. So it enhances the judicial fairness, that in the discretion of the court, if it looks like something very, very important, little more serious, in-depth problem where it cannot be tried by the procedures of the summon, it might be converted into warrant, and a rehearing can happen. So this is something which is addressing the serious offense. There is a flexibility to convert the type of the case also, and this gives a flexibility to the magistrate also. Now, power to try summarily, which is chapter 8, summary trials. So we will continue with the summary trials in the next video.